All right, everyone, finishing up Chapter 10 with this video covering Sections 6 and 7 of your notes, talking now about the law and broadcast journalism. Let's first start off with defamation. A defamatory statement injures the good name of an individual or an organization and lowers his or her standing in the community. The law of defamation makes sure that the press does not act in an irresponsible and malicious manner. In other words, you can't just go around and saying things about people for the intent of ruining them, if you will. There are two kinds of defamation that are recognized. One is slander. Slander comes from spoken words. It is oral defamation. Libel is defamation stated in a tangible medium, such as a printed story or a photograph, or in some other form that has the capacity to endure. So libel would be largely things that are kept in a more permanent sort of fashion that can be referred back to rather easily. Slander would be things that would be broadcast by and large. Elements of libel. If someone brings a libel suit, he or she must prove 5 different things in order to win that lawsuit. First off, the statements in question must have actually defamed the person and caused some sort of harm. Second, if a story was broadcast, then it fulfills the publication criteria, that it was made available for mass distribution in one way or another. Thirdly, a person must prove that he or she was identified in the story, that it wasn't just a ambiguous sort of reference, that there was no doubt that that particular person was the one that was being defamed. Fourthly, a party must show some degree of fault or carelessness on the part of the media organization. So this can be either negligence or it could be malicious intent. Either way, it could be found as libelous. And finally, the individual has to prove the falsity of what was published or broadcast. So they have to be able to justify that what was said or published about them was indeed not true. And here's the evidence of that. Now, if you are being sued for libel, there are certain defense mechanisms that you have in place. First off, if the reporter can prove that what was broadcast indeed was true, then it is not libelous. Now, with that said, you do have to be careful about opinion pieces, because the Supreme Court ruled that expressions of opinion can be held libelous if they imply an assertion of fact that can be proven false. So, making an opinion is one thing. Making an opinion with stating certain evidence that turns out not to be true, that's libelous. A second defense against libel would be privileged. Used in its legal sense, privilege means immunity. There are certain situations in which the courts have held that the public's right to know is more important than a person's reputation. So in this sort of case, there may be times that the information that is made available because of certain circumstances, because it's part of a current event story sort of thing, where the information was vital, it's possible that that could wind up not being considered a libelous event, even if certain aspects turned out to be proven that the information was contrary to what was actually going on. Thirdly, the idea of fair comment and criticism. People who thrust themselves into the public arena are fair game for criticism. Actors, athletes, politicians all fall into this category. Basically the idea of, well, you're famous, you should expect that this stuff is coming around and about. This defense, however, applies to opinion and criticism. It does not entitle the press to report factual matters in an erroneous fashion. So, again, it applies to the idea that you can't make a false statement about somebody. Opinion is a different thing, as long as it's purely opinion and doesn't have interlaced with it some sort of non-truth associated with it. Now, one footnote here is that every state's libel law is different. I did put a link in your notes if you wanted to learn more about the libel law in North Carolina. But basically, there's different degrees in different states as to what is considered libel and how certain types of speech are protected from the libel law and what certain actions can be taken if one is accused of libelous content. Now, invasion of privacy. 4 different areas that this issue may come up. First off, unwarranted publication of private facts. That might be considered an invasion of privacy. Intrusion on a person's solitude or seclusion. That is an invasion of privacy. So if you're filming somebody when they're on their private property, or inside their house or something like that, that's invasion of privacy. Publicity that creates a false impression about a person, also called a false light, that is an invasion of privacy as well. Trying to create an image of someone in a compromising situation when that's not really what's going on. And fourthly, unauthorized commercial exploitation of a person's name or likeness. If someone did not agree to endorse a product or to be associated with a certain type of business, that can also be an invasion of privacy. Protecting sources. For many years, journalists have argued that their relationship with a news source qualifies as privilege, much in the same way as attorney-client privilege or doctor-patient privilege would be accepted in many cases. Journalists argue that without a promise of confidentiality, many sources would be reluctant to come forward and the news gathering process would be severely hindered. If people were afraid of being outed and that adverse things could happen as a result of that, then that would definitely hinder the release of factual information. And so journalists have argued that they should be extended the same privilege opportunities as certain other entities. To make a reporter reveal confidential sources and information, the government must pass a 3-part test. First off, that the journalist has information that bears directly on a case. Second, that the evidence cannot be obtained from any other sources. And third, that the evidence is crucial in the determination of the case. So, basically, the courts have ruled that journalists do have a certain amount of privilege with their sources, but it is not infinite in terms of how long they can hold on to that privileged information. Cameras in the courtroom. The controversy over cameras in the courtroom highlights an area where 2 basic rights come into conflict, that being the right of a defendant to a fair trial and the right of a free press to report the news. There have been several cases in which a court proceeding has had to move to a different jurisdiction because media have showcased a particular situation in the courts with whatever the situation is in such a way that it may be hard to find a fair jury. because the media has covered that particular incident extensively. All 50 states now allow for some form of coverage. In most states, the consent of the presiding judge is required, and the judge controls the coverage that goes out from the courtroom. Now, advertising. Advertising that is accurate and truthful can be regulated by the state, provided that the state's regulation passes a 3-part test. The regulation must 1. Serve a substantial government goal, 2. advances the interests of the state, and 3. must be narrowly drawn. So in this case, basically what is being said here is that the regulation of advertising has to fall within certain guidelines in terms of promoting the culture and the government's ability to be able to maintain culture and democracy and those sorts of things. Congress has set up the FTC, the Federal Trade Commission. It was created in 1914. Their role is to regulate unfair business practices. In 1938, its power was broadened to include jurisdiction over deceptive advertising. The Commission has developed a set of guidelines that define deception. Taken as a whole, the ad must have deceived a reasonable person, and any kind of falsehood can constitute deception. This is where we get the idea of truth in advertising. Now, there are certain things that is going to entail in sort of a black and white sort of way. Other things, a little more of a gray area. One thing that is permitted in advertising is the idea of puffery. Very formal term, as you can imagine. Basically, these are subjective statements of opinion that the average consumer would probably not take seriously. Statements like, "We have the best burger in town," or "Nobody can beat our prices," or things like that. Those sorts of things that might be either taken sarcastically or taken in more of a lighthearted, persuasive sort of way. Those things aren't considered deceptive advertising. Making claims about a product that a product would not be able to fulfill, those would be considered deceptive advertising. False price points that are published, that would also be deceptive advertising. One footnote here, the FDA also gets involved with this, the Food and Drug Administration. In particular, they're responsible for regulating ads for prescription drugs because there's a lot of different rules that go into place in terms of disclosures that have to air within advertising for prescription medication. So there you go. There's the notes for Chapter 10. You know what to do at this point. Fill out your notes and study questions. Get them turned in. Participate in the discussion board on Blackboard for this chapter. And make sure that you keep a watch of Blackboard and Cougar Mail for any updates and changes to the class.